Yes, we are ready.
Thank you, Vinay. Welcome to our friends and entrepreneurs from Thai Berlin, and welcome to our friends and entrepreneurs from Thai Bangalore. This is a great topic for both of us to meet on. It's also great that we are meeting on ideas of trade and commerce, because this goes back about 500 years between India and Germany, when Jacob Fugger, the Jacob Rich, decided to send a merchant ship, which landed in, of all places, in Goa in India in the 16th century. And now we are picking up the threads through the Thai Connect, apart from the regular business and trade that happens in India with almost 2,000 companies, German companies, working with Indian companies in India, and about 200 companies, Indian companies, working in Germany. With all this happening, what has happened was, in trade and commerce, we've seen many disruptions. Money itself, moving from barter system was a great disruptor. Then there have been so many disruptions in terms of making trade possible, and trade being the fuel that has made progress of several types possible, although we can question what is progress. And one such big disruption is mediation for businesses. But moving from litigation, which for many, many companies which are doing transnational business across cultures, across countries, litigation can be challenging. It can be challenging to understand what the laws are. It can be challenging in the amount of time it takes, as it does in India, as opposed to Germany, which really ranks high in the rule of law index. And in order to leapfrog over these difficulties, we brought in arbitration as an alternate dispute resolution method. So a lot of commercial entities today use arbitration, but many, many companies, as you would hear some of your panelists say why later in the conversation today, are now adopting something which is far more quicker, far more easier, far more party or company centric, and far less expensive in the form of mediation in dealing with possible conflicts which are inevitable in life, whether be it business or whether it's personal life. And you will hear a lot more of this from our extremely distinguished and diversely experienced panelists that we have for you today. And let me start by introducing the moderator, Joy. You can see Joy on the screen. Joy, would you like to wave? Yeah. Joy is on the board and is the VP of Thai Berlin, wears many hats, a chemical engineer by training, working right now on green fuel, green hydrogen specifically, I understand, has been an entrepreneur himself, passionate about coaching and skilling, and an advisor to several companies internationally on sustainability and digitization in the field of chemical engineering. He'll be our moderator today. Thank you, Joy, for being with us.
Thank you, Gayatri. Thank you very much for the introduction. Yeah. I would just like to add that it is Thai Germany that we are part of.
Okay.
You mentioned Thai Berlin. Thank you.
Okay, sorry about that.
No
Thanks
problem.
for the correction. Yeah, it's always good to have a larger universe, being part of especially this conversation on mediation. Yeah. And then in no particular order, but I'll start with one of the prime movers of this webinar today, Ambassador Kanafi. Ambassador Kanafi lives in Berlin, born in Israel, has been an ambassador, has been part of the Foreign Service, Israeli Foreign Service, for over 30 years. As an ambassador, he has been part of very difficult and very important peace dialogues with Palestine, with Jordan, has been part of the UN Special Political Decolonization Committee. He's very close to us in India. He started the first Consulate General of Israel in Bangalore, India, and went on to promote significant collaboration in trade, commerce, and research. He is a member of the Berlin Bar, member of the New York Bar, Ambassador, as well, right? Right. And certified and practicing mediator, passionate about mediation, because he felt the benefits of it in his own personal life. And today has been one of the important people behind the webinar we are having today. Thank you so much for being part of this, Ambassador. And I'm sure your intercultural learning and your experience in diverse continents as an ambassador will be very, very insightful to today's conversation. I will like to now introduce Tara Olapali. Tara is an entrepreneur herself, started and co-founded CAMP, the Center for Arbitration and Mediation Practice, a very pioneering organization which is setting the standards for institutional mediation in India. She's a human rights lawyer by training and also at heart, I must say, and then fell passionately in love with mediation, an alumni of Harvard and many international institutions, and will bring in her perspectives of having worked in immigration, in asylum-related issues, as well as in having started a mediation services organization at a time when you Google for mediation, you get meditation, right? So her experience of how she is building mediation in India at a time when India is at the cusp of a breakthrough in making mediation mandatory in civil and commercial mediation. Welcome to you, Tara. Okay, and then we have with us really colorful, really exciting personality, Axel Angeli. Axel is the a guru in digital technology. He sort of calls himself a digital future evangelist and sort of looks at how technology can fold the future in different ways. He's also an ambassador to the Export Promotion Council in Bangalore, an advisor to many boards and many countries on how digital technology can be used across sectors in terms of Industry 4.0. So I saw some of the work that he was doing on Google when I was looking at what he had written about Woven Africa. So he's working across agriculture, healthcare, nature, and so much more, and put together global alliance of experts, about 50 experts, to provide advisory services and perhaps crucial strategic think about how to use technology in future. He's also the director of Logos World, research and technology firm based out of Germany. Very, very difficult to do justice to the enormous amount of experience and capability these panelists bring in. So this is a little bit of glimpse of who they are. Welcome, Axel, to this panel and to this discussion.
Thank you, I'm flattered.
And we have Satish. He's a lawyer by training, lawyer by profession, also a certified mediator. But thankfully, he's willing to be a lawyer who advocates mediation. And those are really rare breeds today. And we are very, very grateful for that, Satish. Satish has tremendous experience in working with companies in India and Europe. He has enabled at least 125 companies in Europe to come and set up businesses in India, and also is facilitating outbound investments from India. Has enabled a lot of mergers and acquisitions, as well as and beyond being a legal lawyer to these companies, is what he says, first and foremost, a cultural ambassador and a bridge between countries. And that is the crux of also mediation, that it takes into account the cultural, the emotional, and the unstated nuances which law or litigation does not feel is within its ambit. Thank you so much, Satish, for being part of this panel. I'm sure your legal training as well as your experience will be greatly valuable to audience today. I will now hand over the mic, so to say, and the spotlight to Joy. Yeah, all over to you, Joy, and wish you all a very engaging, enjoyable, and insightful evening.
Thank you.
Thank you very much, Gayatri, for the very nice introduction. And, I would like to start by saying that personally, I'm very excited and I've been looking forward to taking part in this session. And mainly because of two reasons. If I may summarize very briefly, is that I think personally for me, it's a pleasure and great opportunity for me to be moderating this event with the experts, in this panel. Thanks, Chuck, for that, for bringing me into this. I think it's a great opportunity for me. And secondly, also, coming from a totally different background as Gayatri was introducing me. So I think it's also a great opportunity for me to learn something new. And I hope I wish the same for all of you in the audience, that you listen, please pay attention and listen to the discussion. And I hope at the end of the session, there will be some key takeaways as learning for me, I'm sure, and also for all of you. So that's why I'm really excited and cannot wait any longer. And before we go into the panel discussion, just I would like to mention a couple of points. Is that we agreed that we'll keep a very practical approach in this discussion, that will follow real life examples without going too much into technicalities of legal, so that all of us can identify with it. And secondly, we also want to make it very engaging. So please, pay attention, and whatever questions comes into your mind, so you can put in the chat. And after this panel discussion, there will be Q&A round with the audience. So definitely we look forward to also engaging with the audience. So it will definitely, looking into the profiles and the 4 experts in the panel, I'm sure it will not be boring. It will be very engaging, but to make it even more engaging, we want to start with a story, because I believe storytelling is a strong part of conveying the message. So we'd like to start with a very small but beautiful story. And the story, I will start, very brief story, but the audience, you have to finish the story. So please pay attention. So it goes like this. Imagine you are a busy mother working in a company, and you are coming back home after a very long days of work. You're very tired, and you enter your apartment, you enter your home, and you hear your 2 children, your son and daughter, they're having a fight. Usual scene. So you go and you find them in the kitchen fighting over an orange. So you see them, the son is saying, okay, I have bought the orange, and I must have it, and because I bought it, so I deserve this orange. And the girl is saying, no, but you bought it, but I got it first. I know I really have, I must have this. I'm hungry. I got it, so I must have this. So they're really fighting, and the mom, you totally get exhausted. Imagine yourself in that scene. So you get totally exhausted, and you come to your own solution. You say, okay, guys, please stop fighting. Enough. I've had enough of this. So you cut the orange into half, and you give 1 half to the son and 1 half to the daughter, and you say, okay, that's it. That is my solution. So yeah, so that's the story. So we have. So 3 solutions. The solution of the son is that he has the orange. Solution of the daughter is that she has the orange, and solution offered by the mom was that everyone gets half of it. So now I'd like to ask you, what you think is the best solution. So you can see the question has been put in the screen. So please, take part in this poll, and let's see what do you think? It's interesting. It's really interesting. More than 50% says, yeah.
Yes, someone says give peels to the son and orange to the daughter, or something to that effect.
Yeah, some interesting comments also coming in the chat. So I think we'll give a few more seconds, and then we'll close this. So almost it's half of between the 3rd and the 4th option. Yeah, really great to see this, this two different answers coming from the audience. So I think it's a perfect setup for us to kick off our panel discussion.
I like one of the suggestions. You eat it yourself.
Yeah. So I think all this different, solution will come under the other. So yeah, why not? So maybe let's, close this poll in 10 seconds. Good. So with this, with this story having in our mind in the background, let's go to the panel discussion. I want to really start the discussion with the panel right now. So I would like to start with Tara and Chuck to start with that, having this story in our mind, I would like to ask with the question that, what is essentially mediation and how is it, fundamentally different from going to court for conventional arbitration? So if you really, set the tone for the discussion with this.
Thank you, Joy. And clearly we have a good group of mediated thinking audience over here. And this story actually, although a simple story, it's not a simplistic story in trying to demonstrate what mediation is. And while the intuitive response would be by the mother to cut the orange in half and give 50-50, one half to one child and the other to the other, there is another way to approach it, which is for the mother to ask, so why do you want the orange? And as some of the responses came from the chat, potentially one wants the orange for the peel and the other wants the orange for the juice, or one is hungry and the other wants to use it for to bake a cake. But essentially, when we move into that realm of trying to understand why the orange is wanted, we are able to expand into a sphere of being able to find better options to be able to settle that dispute. And if you think about it, disputes are an inevitable part of human relationships. And there are essentially two ways, or the way we see it, two ways to find your way out of the dispute. Like in the orange story, it would be to take it, cut it in half, maybe one person in this story explain, I want the orange because I bought the orange, or I want the orange because I've got the orange. And then it becomes a question of, to whom does this right belong? Is it possession or ownership? And a determination is made by the court, which could satisfy, in this case, would not satisfy the interests of both the parties, or to move into an option of understanding what the real needs of the parties are, and then to say juice or peel, and find ways to satisfy that interest of juice and peel. Or even deeper, why do you want the juice? It's potentially to make a cake or to have a dessert, or I want the peel for a medicinal herb that I want to make, or medicinal concoction that I want to make. So we're going deeper to understand what are the real needs of people and how do we find ways to satisfy those needs. And this essentially is one of the ways that we can draw the differentiation between ways processes have been set up to manage disputes. Mediation being that process where you ask the question why, and the court system being the process where we explore what the law is, what the framework of the law is to determine what is right, what is wrong, and who wins the case at hand. Chuck, over to you to explain further what mediation is.
Yeah, thanks, Tara. I think you summed it up fairly well. Just to point out, I mean, you mentioned that the law is going to decide in a case if you go to a judge with the orange. It means one person or the other person is getting the orange. There's really no other possibility. The law is binary. The law says this or that. There's no way to get out of that. So if the parties have different needs or different interests, even if there is a way out of it, you can't find that in a court. A judge can't tell you to go to take the peel off and to give the juice out. And this is it's basically an adversarial system. One person is right and one person is wrong in the eyes of the law. And there's no such thing as the court not giving a decision. It has to decide, even if it's the worst possible thing. In mediation, you have a much more flexibility, and the starting out point is, like you said before, it's not you against me, the brother against the sister. It's you and me against the problem. The problem is that there's an orange that needs to be divided, and it's my problem as well as it's your problem. So that's the starting out point, is that it's collaborative. It's also from another point of view, it's very empowering to the parties because it's consensual. A judge decides something, that's what's going to be. Even if both sides say the judge's decision is bad decision, you still have to obey it because it's a legal decision. In mediation, it's not that way. It's what the parties agree on. If I agree with you that we're going to split this orange and we're also not going to split it now, but we're going to split it in 100 years, then that's what's going to be. If we decide that we're going to go out together and buy an apple in addition to the orange, that's what's going to be. It's whatever we decide. It's not just one thing or the other. So it's consensual, it's collaborative, and it's consensual. And from a business standpoint, it's preferable to court, definitely, because the proceedings are confidential. What we decide is what we decide. Nobody has to know about that. If you go into open court, anybody can come in and sit there and hear what you're talking about. They can hear of your company's problems. They can hear your patents, everything, if they're in the court. So confidentiality is really important. And finally, I do have to mention this, and we're going to go much deeper into it, but it's more cost effective. It's faster. The fees that you're going to be paying along the way are less. You're going to be paying for less times of your attorney. Sorry, Satish, that you're not going to be making that much money this time. But that's also an important thing, I think, for business people. You don't want to waste your time in court. You don't want to waste your money in court. You want to get on with it and do your business. And those are all of these are important. I call those the 4 C's. Collaborative, cost-effective, confidential, and consensual. And I use those C's because my first name is Chuck, so I like that letter too. So that's I think that's a little bit of an overview of how mediation is different from court, and why it's really a new way of looking at solving our disputes that way.
Thanks a lot, Tara and Chuck. So you mentioned, thanks for opening this up in this basis of the discussion. And you mentioned briefly about business. So that is where we'd like to go next, because, I think almost all we are coming from some sort of business background. And I personally feel that in business, dispute, or let's say disagreement, is something inevitable, right? So I would like to come to you, Axel, for the perspective of business. So how do you see this mediation from the business point of view? So what would be your initial thoughts on this?
Well, from a business point of view, I think I'm quite clear. Going to court is not an option unless for people who live from the courts. For business people, we have 2 very important things. First of all, decisions have to be made quick. Chuck already mentioned, if you go to court, it can take very, very long time. So this is also something that can ruin your business only. As a famous example, when Microsoft became big, there was another company called Digital Research in the 1980s. They were building the DOS operating system, and they were a much better company. They had a much better product. And then Apple came and they offered this mouse-based Windows-like Surface. And then Apple sued Digital Research. And Digital Research, interestingly, they went into the fight with Apple because at this time Apple was not so big. They were just a competitor. But they lost the complete business, not the lawsuit. They lost the business because they went to court for a couple of years. In the meanwhile, Microsoft came and took over and the whole business. So speed in making decisions. So I see mediation more like if you go into a football or in a cricket game and you have a referee and you have a dispute, you don't agree that was a hit or that was not a hit, but then the referee makes a decision and everybody says, okay, that is the decision, if I agree with it or not, but the game and the show has to go on. So that is how I see one of the big things in mediation. And the second part with mediation is, other than a lawsuit normally is the end of the game. After a lawsuit, if you lose it, you don't talk to the other party anymore. The mediation, the goal of mediation is actually to keep the people working together in the end. So we need Solomonic judgment and not final biased law judgment, as Chuck already said. Actually, law is partisan, but mediation can be something in between. Just let me add, maybe when I say Solomonic judgment, and not everybody knows what a Solomonic judgment is. That is from the old Bible. It is a woman had a child and he had to give this child away in custody to some other woman, and after a while both women fought actually, oh, this is my child because I gave birth to her, and the other woman said, no, I raised the child, so it is my child. And the judge said, actually, let's put a big circle, put the child in the middle of the circle, and then both have to tear it out of the circle. Or in the Solomonic thing, I think in the Bible it was a sword, actually, to take a sword and cut it in pieces. And the real mother said, actually, I don't want to die. I don't want the child to die. This gave proof she's honest. That is why I also said I would not give the orange to any of them. I would actually, you're not eating anything. None of them will get anything. Bring the orange away. Unless you, but if one of the two children would have said, oh, I leave it to you because I'm very generous, then I would say probably you deserve the orange.
Yeah, thanks a lot, Axel, for your initial thoughts. And I think also it's a very strong message with this story. So thanks for that. So next, I'd like to come to you, Satish. We are now opening this discussion. So I'd really would like to listen your initial thoughts. And I request you to put a stress on the perspective of a lawyer in this context. So over to you.
Thank you, Joy. So how I see is first, when we engage with our clients to draw contracts, we understand the nature of business and we prepare all kinds of clauses to respect the business interests of the client. But in that, one also becomes the dispute resolution, because as lawyers, we also envisage a worst case scenario where the parties get into dispute. So that is where we kind of deliberate, discuss, and come up with different resolution mechanisms. And as a lawyer, I always say that, try and see if you can settle before going to the to the courts and following the process. But that said, mediation has kind of picked up well in India as well. And you have to don the hat of, when you don the hat of a mediator, probably you have to kind of become more collaborative in your approach than a combative style, which is there in a typical litigation or an arbitration. You kind of don a role where you advise your client on pre-mediation, during mediation, and post-mediation. And I would say that the approach completely is different here. And the traditional function of the lawyer, from being an aggressive person and to kind of become a negotiator, or rather a listener, and kind of come to or respect the spirit of conciliation, listen to the claims of the other side, see what can be given, see what can not be given, comes into the mind of a lawyer advising a mediation client. So that is how I would see how it has evolved. But yes, as it is again an evolving concept, the kind of approaches that lawyers are getting more and more interested in mediation is a good sign. And I would say that more and more matters I can see getting resolved through mediation.
Understand. Thanks a lot, Satish. really interesting and helpful to understand this. So next in the discussion, I'd like to bring the influence of the international business. So we are involved in doing business cross border. So in here we are very lucky to have a panel where you're very experienced in multi-country, multi-continental experiences, especially Europe and India if we focus. So I'd like to start with you, Chuck, that if we think of this international business scenario, global business scenario, and then the issue of cultural differences comes into play. So I'd like to start with you. What are your thoughts on this cultural difference in here, especially if you think of Europe and India?
Well, I like to start off with everybody's telling stories tonight, so I'm going to tell a story too. It's not really a story, but it's just an anecdote that when I was working here from the Israeli consulate, I was part of and witness to a lot of attempts to create business frameworks between Israel and India, and I came up with this idea, the saying that when an Israeli and an Indian speak about a business relationship, the Israeli hears business and the Indian hears relationship. And this goes for European audiences, I think, as well. A lot of times businesses falter, deals falter, joint ventures falter, not because there's anything wrong, not because it wasn't economically viable, not because there wasn't a need for it, but because the people don't really speak the same language. I mean, they're both speaking English, but they don't know what each other are talking about. There are so many differences. Anybody who's done cross-border work between India and Europe in either direction knows that a lot of times what's not being said is more important than what is being said. And under these circumstances, it's sometimes difficult for you to get over a misunderstanding that's happened and is threatening your business. In mediation, besides having a trained mediator whose job it is there to get out to get you to understand what your actual interests are and to get around the communications problem and to teach you to communicate on the fly, mediation also gives an opportunity that's an opportunity you don't have in court of co-mediation, where there can be an Indian mediator and a European mediator working together as a team, and then if there's a relationship of trust between the mediators, they can help translate in commas from each side what the other one is thinking, and can then help them to get to a decision that way. And that's again an opportunity that you don't have in court. Somebody from your culture who understands your culture, who understands what you meant when you said X, and to help the parties negotiate from a position of understanding each other, understanding each other's needs, understanding each other's interests. So in a lot of cases, going to court, nobody wants to go to court in the other country. A German company isn't going to want to go to court in India because they're going to think there's some sort of bias there, and an Indian company isn't going to want to go to court in Germany because of that bias. And if you have two mediators there working together, that serves to actually to neutralize that bias. So that's an important thing in cross-border commerce.
And just to add to that, if I could
Sure.
add to that, I think Chuck makes a very important point that the mediation process allows for co-mediation, where we're able to bring in mediators from different cultures to work together. But even in situations where, if it's a sole mediator, for example, the mediator and the mediation process is a flexible process that is about gathering information, about understanding. And therefore, the mediator is trained, especially in cross-cultural settings, to be able to understand the context of both the parties, gain the understandings of why each party responded or reacted the way they did, in order to be able to move to resolution from that space of understanding. So the process is such, and the professional is trained to be able to inquire and understand those aspects of the dispute, which a formal system actually does not provide for.
Just to give you a story here, Chuck, sort of taking Chuck's time for the story from me and elaborating this particular case, a very interesting case where there was a Western boss, multinational company, and there was a Southeast Asian reportee, and there was a case of sexual harassment filed by the boss, saying that, you know, this guy who's my reportee never looks at me when I talk to me and looks at the chest. And it came to mediation, and CAMP looked at it. And what got unveiled, you know, in mediation, which didn't get unveiled in a formal committee of the company, was that the Southeast Asian guy said that in his culture, it was not acceptable to look up into the eyes of the boss and talk to the boss directly, right? And here was a boss thinking that all kinds of lecherous things about this guy. Now, this had not got talked at all. It had become a kind of a whispering gallery, both of them unhappy with each other, not knowing why the other person was behaving in this way. And mediation allowed this to be sorted out and both of them to work together very well and expanded their insights and horizons about each other and each other's culture. So it's a very practical example of how mediation can work in various situations.
Thank you, Gayatri, Tara, and Chuck on this. I would like to, stay a couple of more minutes on this topic, very important, because we are members of TiE Germany here and TiE Bangalore and other. So, I want to come to you, Axel. You have a lot of experience in this regard, India, Germany. So I'd like to also listen to, what are your thoughts on this cultural differences in this context? And also if you can recall of any specific examples.
Mm-hmm. Okay. Well, first, Gayatri, actually, your example, that is a common, well, say we call it nearly a running gag actually in Germany. When Indians come to Germany, normally they come in many people, and everybody reports the experience. Well, whatever you tell them, they always say yes, yes, and then they shake their head, but they say yes, yes, yes. Did you understand? Yes. Did you don't understand? Yes. Are you a man? Yes. Are you a woman? Yes. So no, the point is often a misunderstanding, of language, and secondly, what you said, actually, this devout attitude that they're taught, actually, you do not speak up to your father. And that is this patriarchic method. But if this is a cultural difference, actually, I would doubt it. I don't like cultural differences, the term anyway, not. When I talk with people, when I do project management, I talk about cultural similarities. And between India and Germany, there is a lot of similarities. And what you just described, that is you find in France, for example, very, very common. In France, you have the patron, that is the big boss, and nobody speaks up. And even if I ask some engineer, can you give me your opinion? He gives me blah, blah, blah. But because I should have asked the question to the boss doesn't know anything about it, but the question has to go through him. You have to route it through him. So in France, you find it here. In Germany, it was probably there also until we lost in Germany 2 world wars. And so the attitude changed a little bit in this respect. So don't be obedient just forever. Try also to use your own brain. What I also see is in India, it is changing in this direction. The better the people are educated, the more they say, actually. So it's no longer you have just to listen to this one. No, take own responsibility. So that is there. But what I want to point out, the cultural similarities, if you work on them, you also have the first step to mediation. Because instead of telling why the people are in dispute, tell actually what they have in common. And then if there is a little bit of a dispute, say, okay, well, but we have so much on the positive balance side. The negative side is ruled out by this one. And in the end, you can be friends. And you sit together and you do, like in Africa. In Africa, by the way, Chuck, you might know this one. Then in Africa, there is certain tribes who have a very nice form of mediation. They sit as long until they find a decision, and then they go drinking, and then they vote again. And only if the decision is the same after drinking, then the mediation was successful.
I think that's a fantastic point, Axel, which is when disputes are or differences are inevitable. And when we talk about a process that emphasizes on the understanding of the differences that come from culture, and culture is not necessarily cross-border. It's within families, for example, right? There are differences in the way people understand and perceive the world, and from there come those differences. So a process that accommodates these differences, a process that is structured where there is emphasis on where the similarity lies, where is the consensus, and a constant reminder to that brain, which when in a conflict situation is in a reactive state, to only see the fallouts of it, but to constantly remind the parties as to where the similarities lie and move them into a collaborative framework, is a process that is that centers around efficiency, relationship building, and forward thinking, movement forward, and that's the process that we're trying to introduce to the larger community, the business community, whether we're talking about cross-cultural businesses or not.
Thanks, Tara, and thanks a lot, Axel. I think this is such an interesting topic. I guess we can keep on talking for hours on this. And now that you really raised a very interesting way of looking into this, that don't talk about cultural differences but cultural similarities. And I work in a French company for some years, and I now think of my own situation. Yes, you're right. I see so many similarities between my colleagues and the way I have been seeing in India. So let's change the topic a bit and let's jump a bit into the details. Not much though. Is that I'd like to come to you, Satish, for the next question. That as a lawyer, how much importance would you put in this discussion on the dispute resolution clause? And if you can explain a bit on this, that would be really helpful for us to understand.
Okay. I mean,
and why also, why what it is and why it is very important. Yeah.
So why a dispute resolution clause in a contract is required? Because it lays out a mechanism for resolution of disputes between the parties. And a well-drafted, tiered dispute resolution clause is essential because it gives a certainty as to the process and procedure. And it is more prevalent because I do a lot of cross-border contracts. It is even more prevalent in an international setting where the parties are based in different jurisdictions, because it helps them to chalk out who can help resolve a dispute, when, where, and how. And so typically when we get into the dynamics and the way we draft the contract, we understand what the parties want. But as lawyers, we always say that try and resolve the disputes amongst yourself initially. Then if that does not work, give it a time, say 10 days, 15 days from the time the dispute is declared. Go into mediation immediately after that. And again, if mediation doesn't work, then get into arbitration. And then the last resort would be a court battle. Like the other panelists have been explaining so far, typically as lawyers, we do not want our client to have any disputes, but when they do, we try and see if it becomes time sensitive. I mean, it is time effective, cost effective, and also it's easy to carry out. It should not be like, say, one party is in Germany, one party is in India, and we have kept an arbitration in Singapore, which it becomes a logistics nightmare. So all those gets addressed. So that is essentially how a lawyer perhaps looks into it when a dispute resolution clause is constructed.
If I can jump in
Yes,
there for
sure.
a second, just to add something on there, is that when you're signing the contract at the beginning of the deal, everybody's really happy. Everybody wants to work together. You're already in a collaborative mode. Nobody wants to think necessarily about conflict, but you say, okay, well, if this happens, and then you write that in. And that's the best time to think about how you're going to deal with disputes that are going to come up in the future. We say it's better to decide these things when you love each other than when you hate each other. Because if you don't have that in there, and then something something goes wrong, something has created a dispute within the relationship, then you're not really in a mood to speak to the other person and to collaborate with them. This way, the framework has already been set up. You've already agreed that you're going to mediate. You're going to sit down and talk about this in a more informal way, and already when you look back at the contract that you've signed, you see, okay, wait a second, there is a way out of this without just racing off to court and going into all of these costs and 10 years of litigation and so forth. So the one of the great advantages that you have there is that you've really prepared the ground for finding a collaborative solution from the very beginning at a time when you like each other, when the time we were already collaborating. So that's something that I've found has been critical, is that people have agreed, and then they don't have to find themselves up a tree and having to back down from the tree. So I think it's very important to have a good, solid dispute resolution clause in commercial contracts from the very beginning.
And to add to that, so not only is the idea of through that clause making yourself dispute wise, but as the mediation service provider, as that institution that sees these mediations, there is such a world of a difference when there is that clause in your contract that drives the parties to mediation, as opposed to when there isn't a clause and then convincing the other side to come onto the table to collaborate. So to be able to take that power at the time when you love each other, as Chuck says it, as opposed to when that fight has broken out and trying to convince the other side to come and talk. So make yourself dispute wise through that clause.
Thanks, Chuck and Tara. So actually, yes, I was just coming to you.
Yeah,
so...
I just want to summarize. Just wanted to summarize this because that is a common term also in Germany for the marriage. It suffices to have a handshake and a kiss. The contract is made for the time of the divorce. Or we said actually the contract is for the heirs. That is even more important. You make a deal with somebody and then one of the parties dies. The fight happens. The War of Roses happens with the heirs, not with the actual party.
Great. So Axelas, anyway, coming to you as the next question is that if you think of the perspective of a business owner, so as a business owner, be it startup, be it small, medium, big company, so how do you see a dispute or a disagreement from a business owner's perspective, and what they can do, what they can equip themselves with to come up with the best possible scenario out of a dispute?
Okay, rule number 1, avoid it. Rule number 2, refer to rule number 1. Because a fight is a fight, and there is no war, no fight where you come out without getting hurt yourself. So getting into a fight is extremely difficult thing. So that is why we say mediation, at least that is, if both parties agree on mediation, then there is a way at least to avoid the fighting itself. But there is also one thing when I say, and also in mediation, you can build mediation in various forms, but most contracts are made like the two parties were the only people in the world. They are made between you and me. But normally, if I'm a business owner, I make a business, but I have my employees. I maybe have my partners. I have my bank in the background who has another interest. I have this. So there is so many people also who have interests in me. And when I make a contract, that I make it not only for me, I make this contract also for others. On the other side, the other parties can help me. I have a story that I give regularly because I do a lot of business with people from Andhra Pradesh, naturally, because that is the source of the IT engineers of the world. So you go with the Andhra people. But if I want to do a business with the young people from Andhra Pradesh, then I can sign a contract like the Americans would do, say, actually. What is a contract? He will not even read the contract. He will sign it. When there is a dispute, he will forget that there was a contract. it's a smarter way of doing it with a young guy like Joy, for example. I would say, actually, let's make a contract. We make a big deal about $10 million in business. And then I tell him, actually, let's have a dinner, and you bring your parents. If there is a dispute, I don't call him. I don't call a lawyer. I don't call Chuck. I call the parents. Normally, the dispute is settled quite easily because they're part of a clan, not alone.
That's a really wonder. I think Axel is a mediator in disguise, right? And he's got the heart and the mind of a mediator, because that's exactly what mediation does. It brings your forefathers, your kinsmen, your important stakeholders into the business of your dispute. Therefore, when you're doing your dispute, it's not just you and X, like you said. It is to remind that there is this whole ecosystem which impacts on your dispute and is affected by your dispute. So that's why mediation is so beautiful, that it completely utilizes what is human in us and incorporates it in the process.
Thanks, Gayatri. I think you have so many, interesting questions still. So I'd like to move on. And next, I'd like to go to Satish. There's a feeling around the world, so many things happening around us. So I think there's a feeling that international disputes, international, disagreements will increase. So how do you see it from, if you could, tell about us, how do you see this more and more international disputes coming up, or what is happening?
Yeah, I mean, I have been dealing with cross-border contracts, cross-border disputes for the last 22 years. So when I kind of look into it, I see that it's usually arbitration, which the parties always want to get into for resolving any dispute. In recent times, of course, the corporates are looking for cheaper and probably time effective alternatives. And we have seen that more and more people or clients or businesses are opting for mediation. Also, the United Nations Convention on International Settlements Agreements resulting from mediation, which is the Singapore Convention, was adopted by the United Nations on 26 June 2018. And this aims to provide global enterprises with assurance in resolving cross-border conflicts through mediation, as well as the ability to apply directly to the courts of nations that have joined the convention. So in my experience, just to give you practical examples, I have had instances where there was reluctance when initially we had kind of drafted the contract. It was a distribution contract between a German company and their Indian distributor. When we told the client, consider including mediation, they initially said, no, my lawyer doesn't know what he's talking about. But the moment we explained and told them about a mediation process and how it can be applied, they quickly agreed. And probably, I think 3 years down the line, we were into a state of dispute. The client, again, the German company said, I have a better case. I'm going to go for a court process because I have a better position there. But we still said, no, but you've opted for a mediation route. So why don't you consider that before going to the court? They, with a lot of hesitation, agreed to it. And through mediation, we resolved or we came to a settlement within 6 hours. And with 2 sessions with the mediator. So they were actually stunned because they were from German background, and they said, we did not know that mediation works like this in India. So it was also like a win-win for both parties, and a quick and effective process as well. So we see that a lot of international companies are looking into, including the mediation mechanism in their dispute resolution clauses as well in the contracts.
Great, Satish. I think the examples are really helpful to understand. So, having heard your answers so far, I think we have now a very good so for a foundation to understand what it is. And so now I want to go a bit on the practicalities in terms of process and the cost. So I'd like to come to you, Tara and Chuck, in together. If you could explain for us to understand how the process typically goes, and with some examples, maybe how typically it costs. So up to you.
Okay, should I start, Tara? Yeah. Yeah, I think just to latch on to a bit of what just Satish also said, one of the problems with people adopting companies, businesses adopting mediation, is they have no idea what it looks like. They can't imagine what a mediation looks like. All you have to do is turn on the television, and you have 4 courtroom dramas on different channels at the same time. So everybody knows what a courtroom looks like, or they think they do anyway. And you say mediation, negotiating a person, and so it's difficult for them to imagine it. So I'd just like to go over a little bit of what the process looks like, not going too much into it. To give kind of an idea. So the first step, of course, is if you have a dispute resolution clause, then that says how we're going to choose our mediator. Often it says we're going to apply to a mediation service provider, like CAMP. That's kind of shameless self-promotion there. But that we're going to choose a mediator, or you can choose it kind of ad hoc. Your lawyers can say, hey, I know this person does mediation, and it's a good thing. And then at that stage, you've already come together and you've already decided that you're going to pursue this avenue. The first stage, then, after this kind of formal business of setting up mediation and deciding who and where and whatever, is to lay out the story, is to find out what exactly the conflict is about. Sometimes I've been in mediations where the mediation has ended at that point because the people thought they were talking about 2 different things. And communication has been there. So the first thing is to really lay out what went on and how do we understand that, and to make sure that each side really understands what the other side's where they're coming from. The second stage is then to go much deeper into it, to come in and say, okay, well, what does the law say about this? What are my interests? I have positions. I say I want that orange, right? And I want that orange. It doesn't say why I want the orange. It doesn't say what I'm going to do with the orange. It's a position, and a position isn't helpful to come to a solution. So we look deeper, and the mediator helps you look deeper into your interests on the one hand, and also what your dangers are, what your risk is if you go to court. A lot of people also, they just want to slam the other person. They want to win. They want justice, and they don't know what's going to happen to them if they go to court. And the mediator can help them understand that. Once we've done all of that work, setting up, understanding the situation, analyzing our own interests and the interests of the other side, then we can start to negotiate. And there is the chance for creativity. You can brainstorm. You can say, hey, I'll do this. I'll buy the apple. I'll peel the orange, or whatever it is. After throwing out all of these crazy ideas, then you start to focus in. You start to come in and say, okay, well, which of these are practical? Which of these bring me anything? And then you have a set of possible options that you can then negotiate out as a solution. So that's kind of and at the end of the process, when the process is successful, and it often is, more often than not, surprising as that may sound, when that's successful, then the last stage is, of course, to write up a legally binding contract, a legally binding document, which is just as binding as any court decision. It's a contract which must be performed by the parties. The difference is between the court decision and that is that the parties have agreed to it, and everything that is every word in that contract they have agreed on. And therefore, at the end of the day, performance of these sort of settlement agreements is actually higher than performance of actual court decisions. I think I'm going to let Tara talk a bit about
and Tara, just
what goes on there.
Thanks a lot, Chuck. And I just like to add, Tara, that while you add on the answer about costs, and if you can also bring in, Thai mediation desk, what it is, how it can help Thai members, so that would be great.
Yeah, absolutely. So 2 things to what Chuck said that I want to emphasize is, one, that settlement term is like a court decree that you have written. That's the beauty of a settlement agreement. You have found those terms that are agreeable to you, but it has the legal validity of a court decree. In legislation in India soon, it will be a legal a mediated settlement agreement having the same validity as a court decree. Up until then, we have enough legislation in place where we convert it as a conciliator settlement agreement that has the same validity as an arbitral award. So think about it as a legally enforceable document that you yourself has written. The other point to emphasize is the percentage of cases that actually settle in mediation. Close to 75 to 80% of cases that go into mediation actually settle in mediation. And a large number of them, like what Satish highlighted, is on day one. So even if it's not in 6 hours, it might be in a few weeks, maximum a few months, but we're not talking 10, 15 years, which is what the reality of the Indian court system is. So what can businesses expect when they go into mediation? One, a better understanding of your dispute, as well as the perspective of the other side. Second, your ability to make decisions from the perspective of understanding what your alternative is. So you have a good understanding of what your reality would be should you go to court, and you make decisions to settle in mediation from a good understanding of that space. And second, third, you're working with a neutral who understands the process strongly and whose role is to facilitate you into creative thinking and problem solving so that you find those solutions that are best for you as a business owner. With respect to the Thai mediation desk, Thai Bangalore has been pioneering to understand the need for startups, especially in Bangalore, to be able to proactively deal with dispute situations. Again, disputes are inevitable. And yes, they are to be avoided, as Axel pointed out, but oftentimes it's inevitable, it's unavoidable. The financial pulls, the lack of clarity on roles, misaligned expectations, especially for startups, the propensity of dispute is very high. I'm sure all of you are familiar with Harvard business professor Noam Wasserman's research that indicates that 65% of startups fail because of founder disputes, right? So acknowledging this reality of the high chance of dispute, especially in startup environments, Thai, in its mission to foster entrepreneurship, has proactively set up the mediation desk along with CAMP so that parties or business owners can proactively prevent the escalation of a dispute by accessing processes like mediation. Mediation is essentially a facilitated negotiation. You have attempted to negotiate with each other. That negotiation, unfortunately, did not end in good terms. Now is the term to bring in a third person, a neutral who is skilled in this process of understanding how to get the parties back onto the negotiating table, to engage in a facilitated negotiation and offer yourselves that chance of 75% to be able to resolve, as opposed to face a more difficult eventuality. So this desk has been set up with the hope that the inevitability of disputes in certain situations can be better managed, can be prevented from rising up and moving into that destructive path through processes like mediation with trained professional mediators.
Thanks a lot, Tara.
Jai, I'd just like to add on there, which is important, really important, is that if mediation fails, which you've mentioned it does occasionally, you still have the option of going to court. You have the option of arbitration. All of the options there's nothing to lose by going to mediation, except a little bit of time. And as we've said, this is really small amounts of time. You're not losing years. You're not losing decades. It may set the process back by a few months, but there's really nothing to lose by trying to work this out without going into the court system, because that option is always there in the background if mediation doesn't work.
Yeah, I think we're having a great discussion. Unfortunately, we have to close in at least this this round in 5 minutes, and then we'll go to the Q&A with the audience. So in the last minutes in this round, I'd like to add the last question and I want to hear from all of you, is that individual. Ultimately, we're talking about individuals, right? We're dealing with individuals. So what are the qualities that you think are the good quality of to be a great mediator? So I'd like to start with you, Axel. What do you think? What are the qualities of a good mediator?
Oh, a quality of a good mediator, actually, you have to be patient. You have to be, I think you have to have good nerves to wait until the fight, the initial fight, and the people are powered out. And then you can start the real mediation in the end. But I think you have to have a lot of cross business wisdom also to understand if you cannot look into inside the brain of the people, then it is extremely difficult. So I think the difference between a mediator, a guru, or a priest is not too much different.
Understand. Thanks, Axel. I would like to go next to you, Satish. What do you think?
I put it in a different way. I see that there is no concept of a good mediator, but I would always say that it is an effective mediator is how I would call it. So an effective mediator has to have years of experience, kind of qualities that help him or her throughout the process to narrow the dispute and probably help the parties come to an amicable resolution. So the qualities, if you may ask, how I see, like what Axel said already, a good amount of patience, great communication skills, creativity. You know, sometimes what happens in a mediation, there is a deadlock or an impasse that we call it. So to break the deadlock, the mediator uses certain creative techniques to break the impasse or the deadlock, and again gets back the dispute resolution mechanism into motion. Knowledge, yes, it could be knowledge of law, knowledge of the matter, the financial issues involved in the matter. Of course, certain technical issues, the mediator can always reach out to experts, but overall good amount of knowledge on the process. The principle of neutrality, which is a very essential ingredient for a good mediator or an effective mediator rather. And the last but not the least is a good negotiating skill set that he needs to kind of embark upon to ensure that he manages the process well with the parties by effectively negotiating with them.
Great. So, Chuck, what would be your take on this?
I'm going to talk procedure. I'm not going to talk because I can't talk about myself. Obviously, the best mediator I know is me, right? But and Tara, we're at the same. We're the two best mediators I know. But in terms of process, one of the advantages of mediation, and because it's consensual and because everybody decides, is that you actually choose. The parties choose their mediator. So yes, you should be looking for experience, and you may be looking for industry knowledge, and you may be looking for legal knowledge and so forth. But at the end of the day, after you've looked at it on paper, then you can actually talk to the person, which is not like your judge. You don't pick a judge when you go to court. You get whoever's on the line. And here you get to actually speak to them, and you get to get a feeling for what their approach is, get a feeling for whether there's alignment between you and them and the other people, and if you think that this is going to go anywhere. So I would say that after you've gone through let's say the formal qualifications, the best mediator is the mediator that you align with when you interview them.
Great. So we'll close this round with you, Tara. If you add what you think about this point, and then we'll go to the Q&A with audience.
I'll make that quick because I know we're looking forward to the Q&A session. But to me, I think when you're looking for your mediator, to identify a professional that actually truly understands the process. So process expertise on how to use the process of mediation. It's a brilliant process. So a process skill, someone who knows the process strongly is a good mediator to me. Then, of course, is the mediator that's able to truly live the principles of mediation, which is voluntariness, confidentiality, to maintain the confidentiality of the process, self-determination, which is to be able to work with the parties to be able to help them find their set of settlement terms. And then, of course, there's the aspect of the communication skills that has already been raised. Listening. A good mediator is someone who knows how to listen to the needs of the parties, and from that space, identify what the parties are really looking for. So yeah, process expertise, the principles of mediation, and communication skills.
Perfect. I think we are closing this panel discussion in a perfect note. So thanks to all of you. I really agree with the comments in chat. I see that it was really an insightful and very informative session. So thanks for that. So let's go directly to the Q&A. So I see one question, and I leave it to you, whoever you decide who will take the questions. Feel free to answer that. So one question I see on the IP disputes. We didn't discuss that much about IP issues. So your thoughts on cross-border IP disputes?
I actually would love to share a quick story I had prepared with respect to an IP dispute, because it was an IP dispute that came to our center to help you think about how these IP disputes are being mediated. It was essentially a dispute between a senior scientist who'd started a company, and he recruited a bunch of junior scientists who was part of his R&D team, and within a few years, they left to start their own company. And the senior scientist felt like the junior scientist had actually proprietary a lot of his IP. So he filed a lawsuit, civil and criminal cases, against these younger scientists that had started off their own company. And it was in court for many years. When it came to mediation, the mediator essentially moved the focus of the discussion on whether there was infringement or not to what was the party's real need, what were they looking for. And a couple of things came out very clearly. One, that the younger set of scientists had basically, their lives had come to a screeching halt because of this lawsuit that had been going on. Their company had folded and they weren't able to move on with their lives. So for them to be able to actually find resolution. For the senior scientist, it was his ability to identify and protect his IP. There was a lot of confusion as to what was his IP and what was their IP. So we essentially brought an expert in who worked with the scientist to be able to differentiate. This is the IP that belongs to the senior scientist. The younger scientist agreed to pay for that IP that they had used. And the younger set of scientists was free to use the joint IP that belonged to all of them. So the mediation process essentially moved the whole conversation from has there been infringement or not to let us identify what is really at stake over here and find resolutions from that space. And it was clarity on what belongs to me, what belongs to us, compensation for use of my IP, and then let me move on with my life so that I can move forward. So that's how this complex technical case was managed in a mediation.
Joy, there's an interesting addendum to that question by Advocate Arun Parameshwaran. He says, given that mediation is not confined to borders, and I assume that also because of the ODR that we use, a lot of online dispute resolution processes. What are the cyber risks and threats? I think this would be another 4.0 aspect of interest to perhaps Axel to look at. So I think it's a very important aspect, not really fully digested by the online dispute resolution community, but the risks would be perhaps not so high as, say, fintech or digital finance kind of risk, but there are risks of information leak, risks of maybe confidential information being leaked out without knowing whether the platform is secure enough, right? So in CAMP, we do have an online platform, and these are questions that we ask ourselves. So I think the industry is growing. It's a very important question asked. and in the industries will be engaging with people. I'm so thrilled to have Axel here so we can pick his brain when he's in Bangalore on this topic as well. And this needs to be looked at. So thank you for the question, Arunji.
Yeah, absolutely. And there is also a direct question to Satish from Mr. Shankar Laxman. So the question is, do you think a good mediator needs to be from legal background? So Satish.
Okay, so to answer that question straight away, yes, the legal background helps. But when I did my mediation training, honestly, I had about 5 of them who are engineers. So they also felt perhaps in their line of business where they want to kind of resolve disputes, they would also want to undergo the training and see if they can do it. The training kind of helps them in addressing those issues. But yes, a legal background does help because you kind of weigh, the options of a combative style versus a collaborative style, time taken here, time taken there, what would be the process otherwise. So, you have already got the knowledge of how things will work this way or that way. So that legal background helps, but it is not essential completely. You can be with a non-legal background also, you can undergo mediation training.
I would add to it and say that we need people from different backgrounds. You need a chemical engineer, we need an IT expert. Of course, you make more money now in your respective fields than as being a mediator, but you need people from management backgrounds and diverse backgrounds to come in, because you're bringing those perspectives and those experience into what is a human process, right? So this diversity of experience is very, very critical to mediation per se. And sometimes lawyers have to unlearn being a lawyer to be a mediator. Yeah, Satishji, I think maybe provocative to you, but...
No, you're right. You're right. Because, when we kind of handle, say, family disputes or disputes where a lot of emotion is involved, you do realize that there are more skill sets you need to kind of have beyond legal skills. So I agree on that point. Yes.
Maybe I just mediate on this one. When you look in the history of mediation, who were the classical mediators in history in all the time, in all societies? That were the priests. So we have the rabbis in the Jewish society, we have the muftis, we had the peace justice in the communities there, and we have the gurus in India. If you really had a problem, you normally went to your local guru and actually tried to the senior people and asked them. And so in the end, what they all have in common, they are primarily, in modern terminology, psychologists. They know about the psyche of the people.
Yes.
Less about the law. So with the law, you don't find a solution. You can make a verdict, but you don't find an agreement. The one who loses is always pissed.
Yeah. I'd like to toss in there too, as well, without insulting anybody, though, that at least in the United States, and Tara knows the mediation scene in the US as well. Who does every business want to be their mediator? An ex-judge, a retired judge. And who are the worst mediators? Retired judges. Because they all think, okay, I'm going to decide now. And they sit in the mediation room with a much more kind of evaluative, deciding who's right and wrong thing. And people who come from legal background is important, but it is also important to get people with industry knowledge and people who, again, to go back to what Tara said in the last comment, people who know the process in and out, who have mastered doing these things and mastering the communication skills and have internalized this mediation mindset. That's more important, and in certain situations, of course, it's good to have a legal background. But if you have also good lawyers who themselves are expert in conducting a mediation as mediation advocates, then the actual legal knowledge is a little bit less important, because they've already prepared their clients and said, we're not going in there to decide according to the law. We're going in to decide according to needs and interests. So the better the advocates are, the less important the legal knowledge, I would say, of the mediator is. Having said that, it's a good thing, and myself being legally trained as well, I can't, cut off the branch I'm sitting on.
Absolutely. I think when we talk about mediation, especially in the Indian context, Axel, it is an emphasis that this is nothing new to that extent. These are processes that have been at part of our community for centuries. Societies did have the respected representatives that they approached in times of dispute situations. It's about reminding ourselves of these processes that are inherent to many societies, but now we're professionalizing it. There is a structure to it, and while lawyers are still the gatekeepers of disputes, when a lawyer understands the process and is able to represent their clients effectively, the kind of solutions that parties are able to reach are unbeatable. So this combination of having strong lawyers supporting the process, strong lawyers who know the process supporting the process, as well as mediators who understand people, who are respected by the parties, who understand the process, makes for dispute resolution outcomes that are sustainable, long-lasting, and desperately needed in our world today.
Thank you very much, all of you. I think we are in the last 10 minutes of our session today. So it has been going very well so far. So perhaps we have time for one last question from audience. If in case I missed any question in the chat.
I see Arun has just asked a question on whether India can expect an effect statute for mediation in India. Very timely question, Arun, because India is right now in the process of passing a legislation on mediation. There is a draft that's pending in Parliament, which we hope will be passed in the monsoon session. And with that, we believe, at least all of us in the mediation space believe that that's going to be a real boost for mediation. As Gayatri opened, there is the potential that as a formal system, we will be pushing more and more cases to try mediation. Mediation is still a voluntary process, and parties should have the option to opt into the process if it is the right process for them, but also opt out if it's not the right process for them. So hopefully legislation that will build that culture of trying this process before trying the nuclear option of the court system.
I can say also from my Israeli experience, Israel made mediation mandatory in civil cases at the beginning of 2021. And so far, the experience has been very good with that, not necessarily because of the outcomes. The outcomes are what the outcomes are, but it's exposed the business community and it's exposed the legal community to the process of mediation. As you said, you can opt out, but you do have to sit in a room for an hour and a half and hear about mediation and maybe to try it out a little bit. And I think that a mediation act, again, giving you this option to opt in or to opt out is critical. Not necessarily even in terms of bringing results, but bringing the process of mediation to the awareness of the business community and to the legal community.
Thank you. And now we come to I would say, the last two parts of this session. And before I hand over to you, Gayatri, again, you remember we had this orange story and we had a poll. So we'll have another poll now. So Surya, if you can bring in the poll as a closing question. I think we have only one question, two questions, sorry. So please take your time to put your answers here. Do you have a dispute in mind better suited for mediation than litigation? Cool, more than 90%. How likely are you to add a mediation clause in your contract? Also more than 90%. Close to 90%. Great. I think we'll close the poll in 10 seconds. So take your time to put your answer if you've not already done it. So perfect. So 70% think that yes, mediation looks better than litigation, and 90% seems highly likely that there will be mediation clause in the contract. So I think it's really great note to close our session. So I'd like to thank all of you, Gayatri, Chuck, Tara, Axel, and Satish. I think it was a wonderful experience to have this discussion with you, and it was really insightful, you know, a lot of learnings, and I hope the same for all of you in the audience. With this, I would like to hand over to you, Gayatri, for closing the session.
Thank you, Joy. And let me first start by saying what a great audience we've had, and a great panel which has held on to the audience, you know, with your wisdom, with your insights, with your inputs. What I would say to the members of TiE Germany and TiE Bangalore is that keep this wisdom in mind, the wisdom of Chuck when he says that put in the mediation clause during your honeymoon period so that it serves you when the honeymoon glaze wears off a bit. Think about what Satish said, that companies were stunned that you could resolve a conflict, which was cross-border conflict, I'm sure fairly complex, in 6 hours, right? And this is very, very critical for startups. We are a startup. I have been been a startup entrepreneur myself and mentored several. In a startup where emotions and passions run high, you cannot afford to make conflict a bottleneck to your vision and your goal. And nothing serves you better than adopting mediation if you want to save your business, as Axel said, in terms of the company which took Apple to court, or if you want to save your business and your life for a much longer time, your personal and professional life, and keep the wisdom of the fact that there is a way in which mediation can help bridge cultural gap and highlight the similarities and help you to resolve your polarizing differences that seem to be unresolvable. Very importantly, what mediation provides to you is the ability to carry the wisdom of the past into the future and be the person who controls the destiny and outcome from your conflict. So I would say that, make this a part of your DNA of your organization. And I would say, I saw David Cover from TiE Germany say, reach out to Chuck and reach out to Axel and Joy if you need to talk more. David, we would like also TiE Bangalore to reach out to all of them, and we'll be at camp very happy to set up maybe the first cross-cultural mediation desk together with TiE Germany. Have a wonderful evening, my friends and participants from Germany, and a good night to